I am up. I'm up. Thank you for having me, and you're a terrific crowd by the looks of it.
Oh, don't say
So,
that.
I've been warned.
You've been warned.
Yeah, I worked at the Landlord and Tenant Board over on 3 Robertsbeck Parkway. I worked there for 17 years. My mother got ill, so I took an early retirement and was a caregiver for her until she passed. But I had to generate a revenue somehow and compensate my income. So, because when I was at the board, I knew a lot of paralegals. And so I started my own business at home, preparing documents. I can't give legal advice, but I can provide you with any information that I'm aware of or that is available on the website. I have landlords, I wasn't aware I'm being recorded, but okay. I would have put makeup on. You know, there's a lot of realtors that I deal with, but let's just start off number one. When I was at the Landlord and Tenant Board, landlords and realtors or tenants would call and say, where do I get a lease? We don't have them. Go to Business Depot, go to, wherever, Staples. Then when I retired, a year later, they came out with a mandatory lease. It's not optional, it's mandatory. And the tenant has to get a copy of that lease within 21 days. So you have available to yourselves, what were you calling it, Julio?
The Ontario Standard Lease?
Yes, and it's through your web.
Agreement to lease?
Yeah, okay. Yeah, because a lot of landlords, I'll say to them, send me a copy of the lease, and they'll send me that Form 400, and I said, where's the lease? They said, that's all I have. But it's mandatory that you have it, and there's a lot of good reasons to have it. Number one reason, as a realtor, if you check off that box that says, the landlord and tenant agree that we're gonna serve notices by email, every time you go to show it for a viewing, you can just email the tenant. If you don't have that box checked out, you have to actually physically go to the property and put a note on the door before you have legal entry to go in. It's 24-hour notice, written. It's, I'm coming in this day, this time, for this reason. So the government does not allow you to do like open houses and say to your tenant, okay, we're gonna have a viewing on Saturday from 10 to 4. That's not allowed. The enforcement unit will say, try to minimize the time within like 1 or 2 hours. Coming in at 10 o'clock, show it to a potential purchaser, and move forward. Okay, go in. Now, a lot of landlords call, or realtors call and say, Pauline, I served the 24-hour notice. I'm trying to show it to a potential purchaser. Tenant's not allowing me in. There's a notice called an N5 that says, as a result of you interfering and not allowing me to entry, you're interfering with my lawful right as a landlord. So I'm giving you a 20-day notice, 7 days to correct. Within those next 7 days, you go in and see if you can get into the property again to show it. They deny you entry after being served that notice, then you can file the application for eviction. So the standard lease is definitely mandatory, and all parties have to sign it. If you don't give them a copy in 21 days, the tenant could suspend paying their rent. They'll owe it. Yes,
So 21 days from what point?
signing
From signing
the residential tenancy agreement.
the form?
So you can keep, like I said to a lot of landlords, burn those forms, because, no, you want to gather information to see for a potential tenant, right? So you can use your offer to lease to gather all the information, do the credit checks, do whatever you're gonna do. But you need to transfer that information over to the residential tenancy agreement, and you need to do additional terms. You can put whatever you want on a lease. The key is it enforceable? No smoking, no pets, no guest, all of that. Put it on there, but it doesn't mean anything. The board will not evict if you have a guest. The board will not evict if someone is smoking. Now, the smoking rule is a little bit different. They won't evict.
Where'd I go now?
Hi. Are they joining
Hi,
us?
can you guys
I see.
mute, please? Thank you.
Hi there. How are you?
I'm doing well, how are you?
Lead child.
Okay, so the board will not evict for smoking or pets. They will evict for grounds related to somebody, you said no pets, somebody's got a dog, somebody's not cleaning up after that dog is damaging the property, dog is interfering. You can apply to evict for grounds related to, not because of. On the lease where it says no smoking or smoking rules, you can put it is a multi-unit complex, no smoking, because it's gonna interfere with other tenants, right? A lot of people have, but if you don't put it first, you could say somebody's on oxygen. You have to have a reason why you're saying smoking. No smoking just doesn't cut it. Okay, when it comes to evict. So you can put whatever you want, whether it's enforceable or not is another matter.
So Pauline,
Yes,
even if the condo has,
that's different. Condo code, the tenant needs to comply with the condo rules, and it says that right in the lease. Is it a condominium? And if you say yes, tenant needs to comply with the condo rules.
with the board rules.
Yeah, the board rules.
Thanks.
What form do you fill out for the dog that's pooing and
N5.
the N5?
N5. So you'll give them an N5 saying, as a result of you doing this and this and this, you're interfering with my rights. Stop doing it within the next 7 days, or I'm going to apply to evict. Which means you'll have to go over and do an inspection within those 7 days to see if it's continued. I don't know why I'm so short of breath. Sorry. I guess I gotta breathe. Talk too fast. Okay, so you have a property that you want to sell and it's tenant occupied. Once you have an agreed purchase of sale, and if the purchaser states that they want to move in for their personal own use, provided the tenant's not on a lease, you can give them an N12. If the landlord or purchaser doesn't say that they want it for their personal own use, nothing happens to the tenant. They just have a different landlord. And you need to notify them of who to pay the rent to, who the new owner is, right? Effective what date. But, and nothing could change. I know I have a lot of new owners that'll say, yeah, but I'm a new landlord, I just purchased it, the rent needs to go up. No, it doesn't. So nothing changes for the tenant, other than they have a new landlord. If they say, on the agreed purchase of sale that they want the property for their personal own use, you can serve the N12. And I gave you a copy of the N12, so it's box 2. And to get things moving along, the current owner of the property wants to serve the tenant with the N12 notice. To say, I have an agreed purchase of sale, purchaser indicates they want to move in. So you have to do 2 declarations. Once the N12 is served, then you can start the process to file the application. And you want to do this to kind of expedite things, because trust me, right now the board is 6 to 8 months to have a hearing. So there's a lot of realtors out there that have got a closing that is coming up, haven't had a hearing. In the agreed purchase of sale, it says vacant possession. Now they can't comply with that. So there is a request, what they call a request to shorten time to a hearing, that you could file with the board, and you can say, okay, I filed my documents, I filed them like 6 months ago. I yet to have a hearing, and I've got, I'm quite potentially gonna lose the sale of this property if I don't get an order to evict the tenant. And the board is generally, as a rule, deny everything. Board, there's nothing that is gonna move the board quicker. The board says, or their opinion is, why should your application go before everybody else's? A lot of things have happened at the board. I'm sure you're familiar with dealing with the board before. We used to have a system called caseload. So, you'd bring your application in, we enter into caseload, it would schedule it for a hearing, the board member would hear it, they'd issue an order, and everybody move on. During the midst of a pandemic, they introduced a thing called portal, where everybody has to go in, basically once they give you a file number, and upload and do your own documents. They did that because the landlord and tenant board went under social justice. Social justice is for social benefits. So they wanted the landlord and tenant board to follow and streamline how they do things. In the meantime, the board went 3,000 applications behind. You didn't have adjudicators that knew how to do telephone hearings. You didn't have staff that knew how to input the data. And the government isn't ordering staff, even till today, to go into the office. What they're saying is, because of the union, I have employees people that I worked with, that said, I don't need to go in, it's mandatory. Have been sitting at home for the last 3 years. And they can't work from home because the Privacy Act will not allow Pauline to take this application to my house and enter it into the computer. So what is everybody doing? So you've got 3,000 applications, And out of the 6 offices, like 3 downtown, Hamilton, London, Mississauga, you've got maybe 10 staff. Well, no wonder we're so far behind. Yeah, no, seriously, it's pathetic. It absolutely is pathetic. And then you'll get a hearing, you'll get a decision, supposed to get an order. That's taken 2 months to get the order. And then you turn, because the adjudicators now say, okay, well, I heard 60 cases today. Now I've got to write all those decisions. And then you finally get your order, take it to the sheriff. Sheriff says, well, I've got a backlog. It's probably going to be a month before I evict. So, I got to tell you, and I can empathize with these people. There's a lot of landlords that have just reached the brink of, that's it, I've had it. I had one landlord, he probably shouldn't have shared it. He went over to the property and took the windows out. Because he said, I noticed that there was an accumulation of steam or whatever. I had to order the windows. They're on backlog. I don't know when it's going to be. Oh yeah, no, people are really, people are getting, I had another landlord where his brother that was supposed to move in committed suicide. I mean, this is just, it's beyond right now what's going on. So, everybody's come up with this term, cash for keys. What's it going to take for you to move? No, really, I need you out of the house. So, if I were to give you, I had one realtor, well actually 2 realtors got together, the buyer and the seller, and said, okay, let's throw $10,000 each. They went to the tenant, said, okay, you sign this N11, I'll give you $20,000. Sign today. And he did. Because they were going to lose the sale of the house.
But even the N11, which is the mutual release,
Yes.
they could still sit there
Yes.
after the date.
Okay, so here's my
And
suggestion.
then it still has to go to the court, right?
Yeah, so here's my suggestion. Once you get that N11 signed, provided you get it signed by all parties, okay, if there's a husband and wife, everybody has to sign it. I would file the L3 application and make it very clear on the declaration. Okay, so if you file an L3 application with the landlord and tenant board, the only time those ones go to a hearing is if there's something that requires clarification. So you indicate that your tenants, John and Mary, moved into the unit on whatever date, year, and you only have John's signature, that will be forced to go to a hearing. Because the board is not satisfied that all parties want to leave or agree. I would never, ever give them all the money up front. What I would say to them, and I have a text box that I insert, what I would say to them, okay, put yourself in the shoes of a tenant, which I am, by the way. If my landlord came to me and said, Pauline, you gotta go. Okay, I want you out. I sold the house, you gotta go. I would be panic struck. Okay, number one, I've lived there for 6 years. I'm settled in my ways. I now need to come up with first and last month's rent. I need to find a place that's comparable to what I'm paying now. There's a lot of things that could kind of be a roadblock for me. But if you said, okay, Pauline, I'll give you a termination date of 3 months. I'll compensate you with X amount of money. And then if he handed it to me and I signed the N11, I had a situation where the tenant didn't leave. And the landlord said, well, now what? I've already given them money. Don't do that. Give them what? Even a portion. Just give them 1 month. So at least they can give the 1 month rent, like last month's rent deposit, wherever else they're going to go. And upon surrendering the keys, I will give you the remainder.
That vacant possession.
Vacant possession, absolutely. Yeah.
Sorry, one more question.
Yes.
So, what names do you need on the N11? Say a tenant has been in there for 14 years, and it's obviously month to month at this point, and they don't even know where the original lease is. There's a couple and an adult child. Do you need all the signatures of everybody, or?
Only the ones where there's a landlord-tenant relationship. So at the beginning of the tenancy, if it was husband and wife, child would not be named. Child shouldn't be named on the lease. Other than, if you want to put it under additional terms, there's no purpose to name the children. Okay, the board doesn't recognize them.
Even though now he's an adult?
Well, no, is he contributing to the rent? The key to the definition of a
Let's say
tenant.
he is though, we don't know the situation, because it's been 14 years.
Exactly.
The landlord doesn't even know what the original lease was, yada,
Right.
yada.
So the key is the definition of a tenant. What gives someone the right to be a tenant? The right to occupy and pay rent. So if he's paying rent, then absolutely include him in the N11. There's no harm in that. He can always go to, if he challenges it. So if the board issues the order And if they file a motion to set aside and challenge it, then it'll go to a hearing and they can clarify it there.
But if you have the person who's giving you the checks or the money, then you get them.
Rule of thumb is whoever's on the lease.
If you don't know what the lease is.
Yeah, but if you don't know who the lease is, then definitely the person who's writing you the checks or whatever, and maybe their partner as well.
Yeah, I'd be
partner,
careful with
wife,
that and I'd
husband.
put everybody just as a
You would
caution.
as a
Only
caution.
because, okay, so you got a husband and wife that originally were on the lease. You do the N11, only put it in the husband's name. You go through all this, you get an order. How does the board know that the wife wanted to leave? Like maybe she wanted to stay, you know, so it would be complicated. So I put everybody's names, there's no harm in doing that. Just not children is what I'm trying to say, like young children, because if the
No,
parents
I'm
go,
talking
they go.
adult children.
Yeah, if they probably contribute,
Yeah,
So
if they're
chances are-
contributing rent, let's
then
say,
they've got the right to occupy and be a tenant.
so that means I need their signature.
I would do that,
Okay.
yeah, definitely. But the cash for keys thing, I would stress, don't give all the money up front. Like I say, I had one landlord that had the N11, as soon as the tenant signed it, gave him $7,000, came the day, tenant didn't move, now what? You know, we don't know where we're going to get this money back. Bill 184 changed the jurisdiction for a lot of things. So before, to file any application with the landlord and tenant board, question on there, is the tenant still in possession of the unit? You had to say yes. If you didn't say yes, they weren't hearing it. All other matters had to go through small claims court. Small claims court decided, we've had enough of this, we're not dealing with any more, landlord and tenant board issues. Everything's going to the landlord and tenant board. So even though a tenant's moved out now, landlord and tenant board has jurisdiction. It's just on a different form. And they're trying, since it's new, trying to follow the same rules that small claims did. So for example, if you have a tenant that didn't pay rent, you serve them the N4, you file the L1, the board issues the notices, okay, to all parties to say, okay, you're gonna have a hearing on this day. With the L10, if a tenant no longer lives there, it's your responsibility to serve the tenant with the notice. So people will say, well, the tenant moved out, I don't know where they are. There are some organizations that can help you find. There's one called skiptracers.com or skiptracersca. They will actually locate a previous tenant for you, give you where they're living now and their information. So it's best if tenant's gonna move out, if you try and get as much information as you can, because you probably need it at a later date. For example, if you had ever received checks, you've got their banking information. If they have a vehicle, write down the VIN number or the car number, make and model. Try to, if they, their employer, try to get as much information as you can before the tenant actually leaves. So that's cash for keys. It's a good idea. A lot of people are doing it. Declarations. Once you serve that N12 for personal own use or for you have an agreed purchase of sale, the declaration has to say the words in good faith. Absolute. So you can say, I have an agreed purchase of sale. I served my my tenants with an N12 notice in good faith, and carry on. I've given you a sample of what you should be writing on the declarations. When they moved in, the tenant's name, the fact that you have an agreed purchase of sale, and like I say, don't ever forget those words in good faith. Because you're making a statement of fact as if under oath, so the government wants you to say that.
Are you saying to use those words in the email?
No, in the declaration.
Oh, I see.
There's
So-
two, one for sellers, one for buyers.
Yeah, one for seller and one for buyer. Yeah, so you have to say, and then, so a lot of, this is a debate all the time. The seller agent will call me and say, well, why am I doing all these forms? Like, who's paying for this? Well, okay. From my point of view, you want to get the ball rolling. You want to serve the N12, you want to file the application, do the declarations, and then get the ball rolling, get the application in the queue, so hopefully you'll have an order in your hand before the closing date. A lot of realtors are writing on the agreed purchase of sale that the property is currently tenant occupied and they may require an extension. Now, I had a couple of realtors where the other side wouldn't give them an extension and the deal didn't go through. So it's complex. I wouldn't suggest doing 60 days. I would do 90 days, but that's your thing, not mine. I'm just saying from my experience, the board's not gonna hear it that quick. And you won't have an order.
It's not even gonna hear it in within the 90 days.
No, it's gonna be 6 to 8 months.
Yeah.
They're not doing anything to speed that up. It just doesn't make sense, like.
Oh, no, I know. How do you think I feel? I mean, I would love to have been sitting at home for 3.5 years getting my salary from the government.
Yeah.
I cannot believe that. No, really, I can't. So what the government is saying is, we're investing more money.
Of course they are.
Yeah, we're investing more money. We're hiring more adjudicators or members or judges or whatever you want to call them that hold the hearings. Because they didn't know. We used to have face-to-face hearings. You would walk into a room, there'd be 2 tables, one side, the landlord side, tenant side, paralegals and everything. Adjudicator would be sitting at the dais, and they would hold the hearing. Now they're doing them all by video hearing. Well, who knew how to do that program? I mean, nobody knew how to input the applications, schedule them. Nobody knew how to hear them. Then you had a hearing, then you're waiting 20 days to get an order. I mean, it's just been beyond. So now they're saying that they've got more adjudicators hearing, they can schedule more. And it seems like right now the people that filed in August are now getting a hearing for February. Yeah, oh, I know.
But even I heard that if the tenant doesn't show up to that video conference, then he gets postponed into
No,
like another.
Not
It's
unless, that happens if they ask for an adjournment. But the board member will, okay, so they send a notice out to you, out to me. You don't attend, they'll rule on my evidence
Okay.
in my favor, unless they've asked for an adjournment. And they have to have a good reason.
Yeah, like what are the reasons? Cause I've had my landlords have said, this has been adjourned again,
Yeah.
so.
It has to be a good reason. Either they've just retained a paralegal or a lawyer, and that paralegal has not been prepared or gotten any of
So
the
they
evidence.
change lawyers or something.
Yeah, something like that. Or they can show the board that they are in a hospital.
Why would getting a paralegal just then be a good reason? They would have known why.
Oh, yeah, oh, well, it's a
Yeah,
stall
part of the
tactic.
Yeah, it's a tactic.
You know, nobody wants to move, and the government doesn't want to evict, so where are we all with this? I don't know. No, I mean, the government's position really and truly is, there's no rental properties out there. Like, let's not be evicting people without a good reason. I had one realtor, and I could tell you horror stories, but he had an agreed purchase of sale. Purchaser said he wanted to move in. There was the declaration. The board denied that request because the tenant went to the hearing and said, this is phony. I don't believe for a moment that this is the real purchaser, and I certainly don't believe that he's moving in. They denied his request.
Based on
What?
what?
Oh, yeah.
You have to have evidence,
Well.
you can't just.
'Cause he was not in good faith.
It was not in good faith. No,
To the
Wow.
yeah, to the left, yeah. You know, it's funny though, because the whole time that I worked at the board, and still even now, I'm right down the center. I mean, honestly, I am. I don't favor landlords, I don't favor tenants. The information that I provide is, there's information there. And if you're a landlord or if you're a tenant, as long as you follow the proper procedures, dot all your I's, cross all your T's, everything should be okay. Should you make an error along the way? I had another landlord last night. Went to the tenant in October 10th, served the N12. Sends it to me, wanted me to look over it because he's already filed. I noticed there's a mistake in the spelling of the street.
Oh.
Yeah, oh. So I had to make that phone call. Said, you got a problem. You're gonna have to withdraw that application and redo that N12, starting all over, because the board will not allow you to amend a notice that could lead to an eviction. Those N4s, N5s, N12s, N7s, whatever you want to serve, have to have no errors. And you can amend an application, they'll allow you to change that at a hearing, or a declaration, you can amend that, but you cannot amend a notice, because it's a notice that'll lead to an eviction. So I had to call him, tell him you made a mistake, and now I had to redo another N12 yesterday, and he served it last night. But now the termination date is 2 months later, and his question to me is, but I already paid, do I have to pay again at the board? Yes.
Oh,
Yeah, unfortunately, I mean, I feel for them, but I mean, hey, it's an error. So if I have a suggestion, once you do a notice, pass it over to somebody else just to read it over. Double check, make sure.
Just out of curiosity, how much does it cost to process?
The Landline Tenant Board charges $201.
Okay.
Unless you're filing online, and it's $186. Depends on the applications, but for me, I'm $200, and $200 covers the N12, the L2, the declarations, certificate of service, and credit card payment form.
Is that
None.
just 200, is that 200 an hour, or that's
No,
200 for the
200
whole
flat fee
transaction?
for everything.
Okay.
Another thing the board did, and this just blew my mind. So you send your application in, and the last page has your credit card, right? Well, it's asking you for it, so you put your credit card. Security Commission came in and said, no, wait, whoa. You can't have these applications with credit cards information on them. Shred them. They went through and they shred them all. Okay, so you have to have a separate credit card form. If you put your credit card information on the application, it's getting shredded. I got a lady right now at a post office trying to retrieve mail she sent yesterday because she filled out the credit card.
But
I
if
said
it's
you're-
there to fill out.
Yes,
So it's not their fault that they're filling out something that's.
you're absolutely
there.
right, it's not their fault. But it says on the website, see, they think people are gonna read the website. But that doesn't, number one, it's so convoluted, you don't know where to go to get in there to read it, okay? But if you fill that out, they're shredding it. So now on some of the applications, they've removed that page,
Yeah. you gotta
okay?
do
And it
that.
says, fill out the credit card information form. And I put X's through it all, cause I don't want people to fill it out. But this lady said, well, I seen your X's, but I put it up top. Okay, all right, I don't know what to tell you. Yeah, take. Yeah, that's
So-
craziness. Hi there.
Can I ask a question maybe
Yes.
related to tenants not paying?
Yes.
Is why don't we have
Victoria.
a more straight approach into the guarantor? All of these forms, there's hardly any
Landlord Tenant
guaran-
Board doesn't recognize guarantor.
doesn't recognize a guarantor.
No, the only time it comes into play is for collection. So you have a guarantor on your lease or your schedule of parties or additional terms, because you can't name them as a tenant, right?
Right.
So once you get an order from the board doesn't collect the money. You take it to small claims or a collection agency of your choice. Say, oh, by the way, I have a guarantor for that. And small claims will address that for the collection. Yeah, Landlord and Tenant Board, that's because the Landlord and Tenant Board doesn't collect the money. So the guarantor serves no purpose.
Always put them on the list.
You should put them under additional terms, not on the lease,
As a
because they're not a
guarantor.
tenant.
Yeah.
And they're not a landlord.
So what would you put in
We
additional
didn't collect
terms?
them.
Under additional terms, I just write the current tenant has a guarantor and name them. There's a special form, I don't know if anybody here has them, but somebody was telling me there's a special form for guarantor only. So if I was your guarantor, I would have to sign something. But I don't know what that form is, because the Landlord and Tenant Board never dealt with that.
But again, so it's nothing to do with the landlord and tenant
No.
board, that's just there for small.
For
Not just
collection,
for collection.
Okay.
collection purposes. Yeah. Okay, I was told you have a lot of
And then
questions.
when you have a guarantor, and let's say you're doing the eviction or you're getting them the cash for keys, do they also have to be one of the ones to sign? Or
No,
It's just
absolutely
the
not,
occupant?
no,
Okay.
yeah.
And then coming back for the question, you said, what if it's a child, 14 years?
Uh-huh.
You said one of the terms is the landlord and tenant relation, so one is an occupant, one is the pair, right?
Yes.
So the child becomes an occupant, no?
Well, they're an occupant, but the board could care less. I mean, if the board is evicting the tenants, sheriff, when he comes, is gonna take everybody.
Okay, then I have another situation where I have a tenant and they're older. One of the partners has died, the other one is close to coming into it. But the kid has moved into the house and now taking care of the
The
father.
parents.
So they're aware that when he goes, I'm not gonna be giving it back to them, I want it back. But I have a feeling that he now becomes the occupant, is that,
If he pays rent. If you've accepted a rent from him, yes, he's a tenant.
but I've been accepting it from the father.
Okay,
Father passes away, but he still chooses to send over the rent. And he's sending it to me because let's say it's through e-transfer. So
right.
he's got my email.
So the definition of what gives a person the right to occupy as a tenant.
Yep.
Number one, they're in there. Two, they're paying rent.
Okay, and then now everything is set up on auto deposit. You send an e-transfer, it's
So
automatic.
you don't really know where it's coming from.
Well, you know where it's coming from, but you may or may not want it to accept it.
Well, that
Then
would
you
be,
have to return it, right?
that would be your choice not to accept it. You need to serve some sort of a notice to say, either that or file an application saying that there's an illegal occupant. or the landlord, I mean, not through his not fault, he died, but transferred the tenancy over to somebody else.
They're not
So
allowed
they
to do
assigned
so,
it.
But they're not allowed to do that without consent.
That's right, but a lot of people do. So that's why they have the application to say, the tenant assigned the unit without my consent. Then you list who the tenant is
Okay.
and who the
What form do
occupant
you
is.
fill out to,
A2,
sorry,
A2,
the A2?
yeah, there's so many A's, B's, D's.
And this is-
Would you feel better sitting down?
Could I, do you mind?
Sit down.
Thanks, guys, I didn't
Sorry.
wanna do
I
that.
should have jumped in before.
No, that's
Are we
okay.
opening it for questions? So, let's do it in some sort of order and,
I have a question regarding the e-transfer.
Yes.
So, you know, when you're sending the N12 and you're giving them 60-day notice, so they shouldn't be paying any rent for the last month's rent, but they go and e-transfer you that last month's rent. The e-transfer, like, just automatically goes into your bank account.
Yes, and that's
So
fine.
then, but you don't want that last month.
No, I know you don't want it, but you
So-
might need it, cause they might be in there till December.
So you just take it regardless?
just
You
take
don't
it.
try
The
and
board-
return it?
No, the board will work all that out at the hearing. Cause a lot of landlords say, okay, when I gave the N12, I have to compensate them with 1 month's rent. Okay, on or before the termination date on the N12. My tenant has a last month's rent deposit. So I'm gonna use the last month's rent deposit for the last month of their tenancy. I'm gonna tell them they don't need to pay me the rent this month, because I'm applying the 1 month's compensation. But what happens if the tenant's there for another 6 months? As long as the tenant's there, they're required to pay rent, and you may have a harder time getting it after.
Yeah.
So just keep on, continue doing what you're doing. If the tenant had paid any extra money, the board would order it back. Okay?
I guess maybe
But I
if
think that's
I could elaborate on
That feels like a
Agatha's point.
catch-22, you know, because then it's also implied landlord-tenant relation.
Well, there is still a landlord-tenant
No, but
relation.
when
until they
the
move.
original tenant has passed away, now
Yeah.
I would like to call him a squatter, has come in, and he's paying the rent, right?
Right, so the
Maybe-
board would make a determination if the tenancy was transferred over or assigned to somebody else. There's a difference between assigning and subletting. Subletting, I'm renting someplace, I go to Cuba for 4 months, I bring you in, you're paying the rent to me, nothing in my tenancy has changed, okay? You pay the rent to me, I pay my rent to the landlord, we can all carry on. When I come back, you gotta go. Assigning means, laughing. Assigning means you're assigning the whole unit. I'm not coming back. I'm assigning the remainder of my lease over to somebody else. I had one landlord that tried to, or one tenant that tried to assign it, but she was month to month. Well, what are you assigning? You have to have a lease from a start to an end. You can assign the remainder of the lease. You can't assign a month to month for however long, when. No, that doesn't happen, so.
But are you still on the hook, or just the original tenant, or when assigned, are you still on the hook, or
Well, no, if they're gonna assign it, how do you mean? If
landlord?
that-
I mean, the landlord has to sign as well. It's like
Yeah,
this is the
landlord
new
has to agree.
tenant. Yeah.
What you have to say, okay, if you were my landlord and I want to assign the unit to someone else, I have to send you a letter
Yeah,
asking your permission.
yeah, and there is a permission.
There
and
is
then
permission.
So it's like a new tenant. I'm off. Yes.
We're taking over the remainder of the contract. Nothing changes, you can't increase the rent, everything's the same. You have to respond in 7 days. If you don't respond in 7 days, saying yes, Pauline, or no, Pauline, then I can give you a notice of termination. Yeah, you have to respond. If you don't respond, or if you say no, I give you a notice of termination. Yeah, so I wanted to say, there's a lot of information on the website. It's just really hard to maneuver. So if I send, like I've got it written here, and I was kind of hoping I would have had a whiteboard, but I don't, so move on. Give you the website so that you can go in. Once you go, okay, www, of course, www, Tribunals Ontario,
Sorry.
www, tribunalsontario.ca.
The tribunals plural, or
Yes. Tribunalsontario.ca. Once you go in, and then you go into the landlord and tenant board, there's a lot of panels that'll come up. Go into the landlord and tenant board, and on the left, there's a ledger. you can go under forms, and then it'll come up on the right-hand side with all the different forms for a landlord, for a tenant, and for the instructions. You can also go in, under decisions, and see the Canelli, or however you pronounce that, the decisions the board has made on the website. Okay, so I've printed a lot of orders, like decisions that have been made before, because sometimes we got cases that are complex and we want to see if a decision was ever made. I'm just trying to think of the one that was overturned. Okay, so for example, this is good to know. You have a tenant that says, okay, I know there's competition, there's few rentals, I want to pay a year up front. The government says that's illegal, okay? You can only collect 1 month's rent and a last month's rent deposit. And the last month's rent deposit has to be equal to your 1 month's rent. They said, well, I didn't ask them, they forced me. They wanted to pay. Okay, so there was a decision made by the landlord and tenant board that says, no, that's an illegal rent collection, you're ordered to pay back. Landlord went to divisional court and got that decision overturned because they said he had evidence to show the offense under the act reads, it's an offense to ask or receive anything other than 1 month's rent. So he had the decision overturned because he satisfied the judge in divisional court that the tenant, he didn't ask, yes, he received it, but the tenant just gave it to him. Like he's got a paper trail, I didn't ask for it, they gave it to me, they wanted to secure it. So the landlord and tenant board right now is kind of undecided as to whether to issue orders to say, yes, pay it back, or whether to hear all sides and say, okay, there was a previous decision made by small claims court, or by divisional court, that overturned our decision. So a lot of realtors are using that, or agents that go into the board
So we say voluntarily. So
voluntarily.
if, you're offering as a tenant, say if a tenant voluntarily offers to pay.
Yeah, it's challenging, and like I say, if you want to take that chance, the board would automatically order you to pay it back. That's a definite.
Yeah, but you're waiting 8 to 12 months anyways. So
Yes,
you're-
yes,
So you might as well take
yes.
me to court, and by the
Yeah.
time he gets there, you're already done.
And that's what a lot of,
Yeah,
that's,
exactly.
that's a lot of people's position right now. And the board can fine, like they can fine you up to 25, or 35,000, pardon me, has changed, for a small, like an individual landlord.
You know, the landlord tenant board is still living in the 80s,
Oh my
70s.
goodness.
Do you see any reform coming? Like this is.
No.
Is there anything in the making? Any?
I would like to think that, no, I mean, hey, they take at least 2 years to move on anything. I mean, I heard on the other day that they said that they're bringing in more adjudicators and training them. You know how long that process takes to train? Like I said, I had 17 years experience. I took my app home with me when I retired. I thought I've been using it, it's mine, I'm keeping it. But, I mean, it took me years to learn all the procedures, the forms, what happens.
But on the archaic system, like there needs to be a big reform that needs to happen because.
Yeah, but that really kind of irked me off because when I started at the board, probably about 5.5 years in, we were receiving awards out of the yin yang because, you know, really we were. I mean, Australia, what a perfect running machine, you know, like you people file an application. When I was at 3 Roberts Beck, if I was at the front counter, you walked in as a landlord with an application, I would date stamp it, I would input it while you stood there, I'd give you a file number, 3 to 4 weeks, you'd have a hearing, the adjudicator would make a decision, he'd get an order, and take it to the sheriff. Period. Now, like, I'm not sure what planet we're all on here. Like, you try to go into that portal and see, all it'll say is, and they don't tell people information. So they create a portal, they'll send you a file number and a PIN number. Say, okay, here, basically you're on your own. Go into this portal. Well, okay, now what? And if you go in the portal with your PIN number and then decide you want to hire a representative, you've already used that PIN, he can't go in now. So we're all, the blind's leading the blind here.
Yes.
I guess I'll be starting to take out some windows.
I have a small thing. We rented a condo to a very nice couple, and the landlord, it was not in an offer, it was kind of, landlord required that he gonna inspect the unit like every month to see You know, whether everything is
Yeah,
fine.
well, I'd
Of
be
course,
filing an
everything was
application.
fine, but is it something kind of legal or?
No, well, okay, so,
What about the
It's
tenant? Can
affecting
he
the
refuse
quiet
this?
enjoyment.
okay, yeah, absolutely. So,
Enjoyment.
yeah, no, really, so absolutely. Everybody has a right to file an application. What you might deem, okay, I won't. My landlord's not coming into my property every month, I can tell you that. He's interfering by reasonable enjoyment. So I would file a T2 application saying as a result of what the landlord's doing an inspection every month, he's interfering by reasonable enjoyment. And I could be asking for a rent abatement. I could be asking for my whole rent back. I could be asking for up to $35,000. I would never get it, but you have to ask for it, or the board won't consider it.
But
When he-
what if the tenant signed on the agreement to purchase and sell that they agree to this?
Okay, so I mentioned earlier, you
That
could
is
put
not-
whatever you want on that lease. It
Yeah.
depends if it's enforceable.
But if they've signed this
It doesn't
contract,
matter,
it
it's not
shouldn't.
enforced, okay, so nothing can contract outside of the law. So my landlord could say to me, Pauline, you need to do cartwheels down at Eglinton every night at 7:00. And I sign it, it's not enforceable anymore. He could put whatever he wants on it. Unless it's in the act, it is not enforceable.
I have a question regarding clauses that we insert for the recovery of, rent and expenses of the filings and all of that. So, there's a clause that I insert in there. And when I had a client that, the tenant ended up going and not, like going missing and there was no rents, and he's like, oh my God, thank God you inserted that clause. But at the end, so you're saying that once it goes to small claims court, is there gonna be any recovery of all the expenses you're putting in through paralegals or lawyers or all of that?
No, and you're not
No.
gonna go after Bill 184 now, you're not gonna go to small claims court.
Right, so
You're
if
gonna
it
file
goes
the
to-
L10 through the landlord and tenant board, and you're absolutely right. That L10 application now allows you to recover any arrears of rent. Tenant moved out, now you notice that there's all this damage, you can write for damages. You can write for legal expenses. There's everything that you can write on that L10 that you weren't able to do before, because the board did not have jurisdiction to order. Now they do.
And that when did that take place? Like that's already
That was
ongoing?
September. No, that was, yeah, it's
That's
already
ongoing.
enforced. Landlord and tenant board had a little bit of a challenge trying to, here's a new application, okay, now how do we deal with this? They weren't familiar how to enter it, how to hear it, how to order on it. So now they seem, and I tried to find some decisions, well, there aren't any yet. It's too soon, so.
So you say it's L10?
L10.
L10.
Yeah, the tenant has to have moved. So I got a lot of landlords right now that said to me, Pauline, this guy owes me 6 months worth of rent or a year's worth of rent. They've done so much damage to the property and my, like I say, I can't give you legal advice, but my opinion would be serve the N4, file the application, get him evicted. Once you have him out, you can give a total estimate of all the damage. You'll see what's wrong with the place. If he owes for damage for utilities, file the L10. But at least get him out, get him evicted first and then go back and see if you can get the rest of the money.
So the N4 is for damages caused to the unit,
N4 is for arrears of rent, N5,
N4 is for arrears of rent.
right, N5 is for damage.
N5 is for damage.
Now, if you have an extreme case like I did last night, there's an N7. N7 seems to go to the top of the pile, that application. And N7 is a 10-day notice of termination. Let's say I had a wild Yahoo party on the weekend and somebody got thrown through the pane glass window and got stabbed. As a landlord, I would serve the N7. As a result of that, you've interfered with my enjoyment. I'm asking the board to evict. The difference between an N7 and an N5, N5 gives the tenant an opportunity to comply. Stop doing it, okay? I give somebody an N5 to say, you're playing the music every night till 2 a.m. For the next 7 days, you need to stop doing it. If the tenant complies, you can't file. If they don't comply, keep doing it and doing it and doing it, then you file your application. N7, there's no time to, no way to correct it. So the board doesn't like landlords giving the N7. And they'll deny a lot of those cases and say, no, you really should have given them an N5. Give the tenant an opportunity, I guess what, not to have another party and throw somebody through a window? It's almost ridiculous. The only time I really suggest using the N7 is box 4. It says, you and I live in the same building. And as a result of what you're doing, you're interfering with my enjoyment. So I have this landlord that has a house with a basement unit that's rented. She's an elderly lady, and the tenant down in the basement keeps on forever calling an ambulance, calling police, having parties, inviting homeless people. So he's really creating havoc in her home. So we did up the N7 last night. We checked off box 4. As a result of what you're doing, you're interfering with my enjoyment. That's the only time I really use the N7.
We were going through a inspection with the fire department, and the gentleman was smoking in the room, and he disconnected the smoke detector.
Yeah.
Is that an N7?
No, N5.
N5.
Put it back up and stop it.
That's fine, but now you're not there, so this
I
can
know,
cause
so
a
this
fire.
so this is why you need to go in and do an inspection. So you give the N5, you give them an opportunity to comply, see if it's there. If it's not, then file. If it's there, great. If you go back, let's say in 7 months from now and if you came to my house every month doing an inspection, I'd file an application, there's no doubt about it. But if you have grounds and a cause where you can justify it to the board that the reason you're going back in 6 months and doing an inspection is because you've just went all through all this with the fire department, so you wanted to ensure that the property is secure.
But you see, like we see how the things change from 70s, 80s, 90s,
Oh, yeah.
like you know, like this more for tenants than for landlords, definitely. And I just give you the one example because, by the way, this N5 and 7, like you give them opportunity. Like you call the police, you know, when
Police
there
will
is a
act.
party, you know, and so then at least you have a report.
Yes,
you know, if
as
that-
evidence.
you know.
But the police will tell you, like we train the police. The police will tell you it's not their jurisdiction, it's the landlord and tenant board.
Yeah, but it's
Anything
just-
criminal,
yeah.
yes. Anything, somebody threw something through a window, yes, that's criminal. Somebody is, passed out on the street, that's criminal. Yes, police will deal with that. But as far as getting a tenant evicted, no, they won't deal with any of that. They'll tell you to come to the landlord and tenant board. And I really have to disagree, because there's, like I say, there's applications that all parties can file. It's just a matter of knowing your rights and knowing what you can file. I know it seems that way, and I can't tell you how many landlords have said, oh, well, this should be called the tenant act, because you are always in favor of the tenants.
I have a good example. There was sometime in 80s, was one agent who was in our office. I remember there was a story about there was a house and a basement apartment, and it was all professional tenant, yes, who was not
there's a
paying,
lot.
like you see, and she was
And
like,
not unpacked.
you can sue me, this kind of thing. So you know what? There was extreme measure. It was not the winter, but when she went to work, the landlord, the owner, took everything out from the apartment, put on a curb. She coming back from the house. What have you done? Now you can sue me.
Yeah, well,
that was the
but I mean, okay,
extreme
so,
measure. And
yeah,
then
it
what happens
was.
then? The police
And-
will come in, or whoever.
Yeah,
yes,
so-
will be,
So in answer to your question, the tenant then could file an application called a T2 for an illegal lockout. That application is going to the top of the pile.
and then what you will be probably in 2 weeks or in a month?
Oh, earlier than that. It'll go to the top of the pile, because it's an illegal lockout, it's an offense.
What's the fine for that?
Up to,
Yeah.
right now it's 35,000.
Wow.
But they're saying 35,000 for an individual, 100,000 for a corporation.
What about removing the windows? Is that illegal?
Oh yeah, but the tenant, when COVID hit, and all of us of government went on TV and said, okay, if it's a difference between paying your rent, putting food on your table, go ahead, put food on your table. They got to finish the sentence and say, that rent's still owing, you owe it. You got a bunch of tenants yahooing out there, advocates saying, I don't need to pay my rent, and so for a year and a half, almost 2 years, landlords weren't getting rent. So this landlord said to me, I'm already past the max that I can get from the
Yeah.
board, go ahead, find me.
Yeah.
Can I ask you a question about the N12? Actually, I'm not sure if it's the N12. So say the landlord wants to redo the entire building. There's like plumbing that needs to be done, maybe update the.
N13.
That's the N13. And
I'm lost.
and tell me about, so once they renovate everything and do everything, my understanding is that then the tenant can come back at the same rent amount and everything.
Absolutely,
That's why on the way out, you offer them cash for keys.
that's right.
And
But you're talking about the multiplex, like a sixplex or something like
Doesn't
or
matter.
Yeah, you're absolutely right, the N11, cash for keys with the N11,
On the
get
way
the
out.
tenant
On
to
the
sign
way
on the
out.
way out.
On the way out.
Yeah, the
So
tenant
in a
has the first right to
situation-
refusal.
So in a situation where there's actually been leaks because of the plumbing issues and stuff in the building, is it better to then do the N11, the mutual release, or to file the N13?
If you can, well, okay, in order for you to file the N13, you need to say to the board that the renovations are so extensive that I require vacant possession and permits.
Permits.
Okay, and then go ahead and file. And you're absolutely right, the tenant has a first right to come back. Tenant needs to notify you of a forwarding mailing address so that you can contact them, say in 6 months, 8 months, 9 months, whenever it's ready, okay, come on back. Tenant comes back at the same rent they were paying before. Sometimes, like you said, if you were thinking that it's gonna take a long time, and I mean, let's be honest, landlords are not only doing this just because there are repairs that really need to be done, they're doing it because they can't increase the rent more than 2.5. So they wanna get those people out, have a vacant unit, and rent it for whatever. So if you think the tenant would be willing, I mean, the tenant's moving anyway, so if the tenant would be willing to sign the N11, by all means, get them to sign the N11.
So how much notice does the N13 require?
120 days.
120 days.
And you have to, if there's more than 5 units, you have to compensate them with 3 months worth of rent or provide them with another unit.
There's a couple of companies that have come out now that allow landlords to report late payments to the credit bureau. Is
Yeah, I'm
there-
really shocked with that because, like I say, even in the orders, they're redacted. They will list the landlord's name because under the eyes of the government, the landlord's operating a business. So that's public knowledge. But the tenant's name is PC. They never put the tenant's name on those redacted orders. So the landlord and tenant board did never keep a registry of applications that were filed. So I don't know.
This is
No, so-
probably prior to filing,
No,
right?
no,
When
no.
they start
So
getting
from
late.
what I've heard is there's, for example, Landlord and Credit Bureau is the website you can go on to. You register as a landlord, you pay $20 a month per applicant, and you can report late payments by the 15th of every month, and you don't need approval from the landlord and tenant board.
I'm really shocked that the Privacy Commission will allow them to do that.
Yeah, and then in order to report good payment, you need the tenant's signature.
Yeah, I'm really shocked.
Doesn't make sense.
Things I've obviously,
So it's on the landlord and credit, and then now there's 3-4 companies that have started to come out, and you just hear this stuff. So is that legal or? Is
I have no opinion because I don't even know who they are.
So we'll talk about
They've
this
never
after.
been
I
around.
would say the privacy commissioner just
Yeah,
hasn't gotten to it.
I'm really I am. I'm
That's a
stunned.
privacy issue.
Yeah, because the landlord, a lot of people. Matter of fact, I remember we had at Robert Speck we used to have a TV up, and on the TV it would list a file number and what hearing room they were going in, and then address of the rental property. It wouldn't say the names of people. I mean, the Privacy Commission wouldn't allow that. You can't disclose all of that information to the public.
No, you're not disclosing it to the public, you're putting it on the credit bureau, so of a late payment.
I would have thought it would have been
Or
only.
Equifax.
I had one landlord say to me, Pauline, my tenant owes me rent. I'm going to and I think it's along this line. I'm going to a collection agency and get my money. I said, are you telling me you can walk into a collection agency without a judgment or without an order
Yep.
and they will collect the money? He said, yeah. Oh, okay then.
Well, to
Let's
the
go.
But this is just reporting late payments, you cannot report damage, you cannot report, it's just
I
reporting
never-
payments, you don't.
I don't know about
Okay.
that, and for me, my schooling was, you would get an order from the board that
Right.
had a decision for 2 purposes, one for the money, one for eviction. You could take that money part to small claims, you wouldn't have to go through a hearing again, and say to them, I'd like you to start collecting that money from me. And so they would give you a 3-page document to fill out to say, how do you want us to collect it? And you would say, I want you to garnish their wages, here's their employer, I want you to seize property, here's what they've got. And then you take the other certified copy of the order over to the sheriff, I want you to schedule an eviction. So, I don't know about all these other places, like I've never heard of a collection agency collecting money. Like that would be like me walking in there and saying,
Well-
you owe me money. Well,
No, it's
well,
not a collection
They-
company, it's
they don't-
reporting on the credit bureau.
So the whole point is that they
Yeah.
threaten to report the tenant
Hurt your credit.
to hurt their credit, so that now the tenant doesn't want that, and
And
Complies
where
with
is their
mine.
justification in that? There hasn't been a hearing. What if the tenant could say, well, no, wait a minute, I did pay, I don't know that money? Like, how credible is that? I mean,
Yeah, there's no proof.
there's no
So I
proof,
think
there's
that-
no, nobody has heard evidence from both sides.
We'll invite you to that webinar because we were supposed to have them, but I postponed it. But there are
Oh.
companies that offer that
As a service.
as a service. Yeah, same as rental guarantees. There are now companies that offer some sort of an
Guaranteed.
insurance
Right.
to the tenants. The tenants pay, let's say, $1,200.
Yeah, things are evolving
Yeah.
quite quickly, I think, but,
To the
No,
landlord.
To the
well,
landlord.
so they essentially obtain these. It's almost like an insurance where you pay like $1,200 to this company, and now they
as
issue a
a security
certificate
that, yeah.
saying, you know what, we have here rental guarantee for, a year. So in the case this tenant
Has it
goes
gotten
bust,
that bad that landlords
has.
can't, yeah.
well, it's so expensive and it's so competitive these days.
It,
that-
and competitive is the word I was looking for, cause I know to go find someplace, there's 6 people standing behind me, so it's a matter of who's gonna get it, right? Yeah.
So what, in terms of your services, you're just helping file, or you're acting almost as a
No, what I do is prepare documents.
prepared document?
Yeah, I could give you information, like if you were to call me, let's say you gave my number out, and a lot of people do, and you said, okay, I got a situation where a tenant's not paying rent. I would say to you, okay, the first document you need to serve is the N4. So if you'd like me to prepare the paperwork, my fee is $200. I'll prepare the N4. If 10 doesn't comply, I'll prepare the L1 and the certificate of service. Send me a copy of the lease. That's what I usually ask for people. And then I get you right up to the door and give you instructions on how to file with the landlord and tenant board.
Gotcha.
And sometimes people just don't listen to me when I give you instructions, because I say, sir, when you're filing your application, along with a signed copy of the N4,
So what will be the difference between you and then a paralegal that is doing the
I
checks
can't
and-
give legal advice,
Okay.
and I don't have a law society number. So landlord and tenant board will not allow me to represent, or anybody represent. You have to have a law society number.
Also, the paralegal will cost much more.
Yeah.
They do, but a lot of times the paralegal, depending on who they are, and I'm still shocked about Stephen Smith, I apologize.
No worries.
A lot of times a paralegal will just charge you, if you've already done all the groundwork and you've done the paperwork, filed, got a file number, everything's okay, they'll just charge you the fee for the hearing. That's how Reg and I work anyway.
Okay.
But just like realtors, there's really good paralegals and a lot of really
Yeah.
not
Yeah.
so good ones.
Yeah,
So you
and
have
a
to be
lot of
cautious.
times, that's not their field of expertise, they could be a paralegal, but specialize in speeding tickets, so it's
Yeah.
different, It's nice to have somebody that is familiar. For me, Reg Bent, I knew, he actually had the first application processed when we were at 4 Roberts Spec, when the board first opened. And so I know he's familiar, he's good with what he does.
And that, he's a paralegal that works with Pauline, and Amitha had gotten some information from Reg, is that
Yeah, I
correct?
talked to Reg first before, and he gave me your name. Yeah.
Because a lot of times if it's getting the paperwork done, he knows, and I'm not trying to be smart about this, but he knows I'm gonna do it right. Okay, for example, because that was one of my duties when I was at the board too. You would come in and you would hand me your application with your notice, and I'd look at the N4 and I knew that there was a mistake, because you went from the first to the first for the rental period. And I'd wanna say to you, it's a mistake. You're gonna go to a hearing, it's gonna be dismissed, you might as well just start all over right now. But they wouldn't allow me to say that. Cause they said, no, you can't, that's giving legal advice, you can't tell them to start over, it's a mistake. Well, I thought, forget this, when I retired, I thought, no, I am gonna tell you it's a mistake. Cause I don't need to adhere to their rules and laws, so now I just say, like the one I had yesterday with a spelling mistake on the N12. I called him and I said, bad news, it's a mistake. I know that application is gonna be dismissed, because you cannot have an error on a notice. A lot of landlords, like I say, will go from the first to the first, or another big mistake. Let's say the rent is due on the first, but the landlord's serving the notice on the 15th, the landlord will put from the 15th. Like, there's mistakes on there, you have to really know the documents.
And can you give more days than less? Like if the
No.
requirement is 14, can you give 21?
What would be the purpose?
Just to be on the safe side. Just, you know,
No
you mailed
safe
out,
sides.
no, but you mailed out the letter, maybe they got it 3 days later,
No, no,
right?
no, okay, so when you're mailing out documents, like
Yeah.
like you just said, there are specific time date, like days on each different notice, right?
Yep.
So the N4 is 14 days, N5 is 20 days,
Yep,
N12, 60 days, there's all different
Yep.
dates. If you're mailing the document, you have to give 5 days delivery added on to that day. So now you're giving 19 days, not including the day of service.
so then usually that's what we should do, just add that extra
Add, yeah,
five.
if
extra
you're
mail.
mailing.
Yes,
Yeah.
okay.
You cannot email, and it doesn't matter even if you got this box checked off, you cannot email a notice to a tenant that could lead to an eviction. You can email, if you've got this box checked off, all parties agree to accept email. You can email notice of entry, all other notices, but if it's a notice that could lead to an eviction, you have to either hand it to them, slide it under the door, put it in their mailbox, or they pick up their regular mail, send it through Canada Post, adding the 5 days. So many people will say to you, Pauline, I'm gonna send it registered mail just to be safe.
Yes.
Now you've ruined it, because.
No,
So
but
that,
that's
yes,
great.
quite
This is-
quickly,
yeah,
I
yeah.
get your point. What if the tenant doesn't sign?
Or they don't pick up.
It doesn't, it's not, now
Yes.
it's not deemed served.
But then if we go and drop it in their door or in the
Yeah.
mailbox,
What
then
proof
there's
do
no
we
proof.
have?
Okay, you have proof because you're completing a certificate of service where you're making a statement of fact as if under oath. I, your name, certify that I dropped it off in their mailbox on this day, and the board is satisfied with that. You're making a
right.
statement under oath when you sign that
Can I go put it
certificate.
there, take a picture of myself? Put it
Yeah, a
in
lot of
there?
landlords do, a lot of landlords fold it up,
Yeah.
take a picture of it going in the
But then
mailbox.
it's the same wording when you're giving it to them via registered mail.
No, but the tenant has to sign for it.
Cause they know who it is.
Yeah, and so, especially in condos, they're not delivering registered mail, how could they? There's, number one, they probably can't get in the building, and two, they can't get somebody to sign it. Condos are a problem though, as far as serving documents, so I always suggest sending them by Canada Post. Tenant gets all their other mail, just add 5 days and send it by Canada Post.
Same problems with small claims with service.
Yeah, well, see, now, that service, now that you're just saying that, is now coming over to the landlord and tenant board. Yeah, but they'll allow you now, with the L10, if the tenant moved out, to serve by email. Yeah,
So with the condo, how, I still don't understand, let's say you are sent to a condo or a tenant, registered mail,
Yeah, but
and you
you-
said that it's pretty much the same as regular, because he's not going to knock the door and ask for the
no,
signature.
you wanna send it by just Canada Post, regular
Regular,
mail. And
yeah.
on your notice, include 5 extra days for the termination date. That's perfect. Cause if you send it registered mail, and it's not deemed served unless the tenant receives it. So the board will say, well, how do we know if the tenant got it? It went back to Shoppers Drug Mart. That's where my registered mail goes if I don't answer the door and sign for it, so.
So now what about the second notice we send out? So we send a regular mail? We've already sent out one registered notice. Now the second notice, how do we send it?
What second notice? You mean the application to file with the board?
Well, we can chat about it afterward, but I've sent out a second notice, but should I send it registered or
Okay, so, no, you're gonna send it out regular mail again.
regular mail?
Attorney.
Okay, and we will talk, if it's a private issue,
Yes.
we'll talk.
Yeah.
I saw online recently that with the property tax increases of 5.5%, that landlords are allowed to apply for a higher rent increase, higher than the 2.5 guideline, because it's an extraordinary
High
increase.
expenses, and you're doing your homework,
Yeah.
girl. And yes, but they can only go up to 3%.
Yeah.
So
Okay.
the maximum this year is 2.5 that they're automatically allowed to increase. They can apply to the board on above guideline increase, call
Right.
them Aggie, because they've had extraordinarily high expenses.
Over 2.5.
Hydro is not one of them. They
Right.
removed hydro from that. So before you used to be able to apply for hydro, now you can't. They have to satisfy the board that they've had those extra high. Now, I mentioned I'm a tenant. The board probably hates me, but by doing all this, but I'm a tenant.
If they hate you, you're saying something right.
My son keeps telling me, Mom, you're going to jail for saying that.
But do you have to put your name down when you're filling out the forms?
No.
So
And
they wouldn't
can-
know it's
can
coming
the-
from you.
If you do that as a landlord, you increase it by the 3%, can the tenant appeal that?
Yes, absolutely. They have a hearing.
They always-
And that's what I was gonna say. I'm a tenant.
Mhm.
So I lived in a townhouse complex. We had this huge windstorm. knocked out half the fences, okay? And the landlord did do the parking lot, so if you're doing, security or nothing cosmetic, but things like
Structural.
structural, yeah, parking lots, stuff like that, paving roofs, stuff like that, you can apply. Landlord applied to the landlord tenant board. I thought, oh, here we go. It was, I guess there was 80 units in my townhouse complex. And they set it up for a hearing and told us that we were all had an opportunity to go to the hearing and maybe dispute it. If we could go into the hearing and say, okay, he's asking for 3.5, he's only entitled to 3. He didn't do my roof. So that's exactly what happened. Number one, we believed that we wanted the landlord to show proof that he actually had to pay for that fence, or for when it went through as an insurance claim. Now, if he paid for it, sure, the money goes passed down to all the tenants. But if he didn't pay for it, why are we paying for it?
But it's not, if there's no damage, if it's just property taxes are increasing, like there's no damage, there's no repairs, it's just the landlord's property taxes increased.
But there's a formula that they have to follow. They can't
Right.
just automatically ask for the 2.5 and
They
then
have to
ask for
prove it.
3. They can go up to 3. But there's a formula they have to fill out inside the, have a look at it, it's called an L5 application.
Okay.
And then what about the raise of interest rates right now? Like, that's a big one.
Has nothing to do with the
So that
landlord
doesn't
tenants.
qualify.
Like that,
Doesn't qualify.
Because
yeah.
mortgage payments are going up too.
Yeah.
I know,
right?
I know, it's unfortunate, that's why so many landlords are
50%.
trying to get the
Yeah.
tenants out so that they can have vacant possession and charge whatever. And the board gets that, and this is why the board is so reluctant to evict. Cause they know what's going on out there.
It's not the
Yeah.
landlord's fault though.
No, it's not the landlord's fault, but it's not the tenant's either, so this is why I say, you
Yeah,
have to kind of, an adjudicator has to sit there and look at the facts, not just feel sorry for one party or the other. You know, they have to look at the evidence and say, okay, this is what's happened.
What about the exemption, the rent control exemption?
Yeah, okay, so if the building was built, if the
after-
building was not occupied, brand new build, wasn't occupied for any purpose before November 15th, 2018, then after my year lease is over, landlord can increase the rent to whatever. And I have one landlord that just did
But
that.
that's only to the first tenant, no?
Yes, yeah, to the first tenant. I have one landlord that, yeah, because then they would have been previously occupied,
Right.
right? So I have one landlord that said, okay, I've had enough with, it's a new build, I don't want him in there anymore. I'm serving and it's an N2, not an N1 notice, and he increased the rent like by $800. So obviously the tenant's leaving. And there's nothing the tenant could do, take it or leave it.
Yeah, I was showing a condo and it's a brand new build, and
Yeah.
that's exactly what I said. I said, just so you know, after your year, you were the first tenant in there.
Yeah.
And
Can
they
increase
the
whatever.
rent, whatever they
So
want.
I've
But if
put
you're
a
the
clause in the
second
past.
tenant, it doesn't matter, they
Doesn't
can't.
apply.
They have to
doesn't
apply rent
anymore?
control.
It's, oh, so after the second.
I didn't know that.
Yeah.
Oh, that
What
I didn't
what the
know.
board is trying, or what the government is trying to do is allow a landlord an opportunity to recover the cost of buying, purchasing, like the money that they've spent up front. But tenants don't know that, and they get a shock of their life when they get an M2 that says your rent's gone up by.
Go ahead.
How enforceable is this? Let's say you are the landlord and you tell your tenant that I want you to move out because I'm moving in, yes? And then tenant moves out and it's not the landlord moves out, he had a new tenant
Yeah,
for
good with
more
that.
money.
Okay,
This is
yeah,
a lot
oh
of
yeah,
money,
no,
yes,
no, that's a good question.
But how enforceable? Because
What do you mean how
I see-
enforceable? Okay, so, a tenant has up to 1 year to file a T5 application saying that you gave me that N5 or N12 in bad faith. Okay, the
Yeah.
penalty for that? If I was paying $1,700 at your place and now I moved
Whole
because,
year.
now I've moved because of the result of the N12, now I'm paying 23. You're paying 23 to me for a year. You have to pay the full rent for a year.
But
Moving
shouldn't
is
it
full.
just be the difference?
No, it was till Bill 184 came out.
Yes, but how in practice, like how
Every
you
day.
see this, but yeah, but is it enforceable? Like, is
Oh,
it really?
absolutely, 100%,
So
every
that's
day.
listening.
And you only, after a year, the tenant can't do anything, the tenant can't come back on you.
Yeah.
But up to a year, and I'm dealing with so many cases like that right now. Tenant moved out because of an N12. Tenant finds out that the landlord did not do what they said, their daughter did not move in there, they
Yeah.
re-rented it. Tenant files the application with the board, they're asking for the rent for up to 1 year, moving and storage expenses.
But if you're taking over, so let's say you're saying you're gonna move in, you get in, you renovate, take 6 months, you occupy it or just leave it empty for 6 months, then 1 year is passed, and then you put it up for rent?
It'll be up to the adjudicator to make a determination whether you serve that notice in bad faith or not.
Yeah.
I mean, the purpose of an N12 for your personal own use, the government's not saying you can't do renovations while you're there.
Yeah.
But if you leave it empty, isn't there something coming out in Toronto that says if you leave it empty
Yeah,
after
they
the
can do
But just to secure, like for example, and things, circumstances change for both ends.
Sure, I got one landlord that served an N12, saying that his mother and father were moving in there.
Yep.
Before they got an opportunity to move in, the mother died. So, I mean, the board has to take all the evidence into consideration in making a decision. That's why they have the hearings.
So, going back to the exemption of rent control, I've inserted a clause that says that the landlord agrees not to increase the rent beyond, let's say, 3%, right? And they have accepted it, and then, coming the renewal, they wanted to increase it. So I said, hey, hello, you
Yeah, you've already had that.
acknowledge that one. Would that be?
No, but again, it's not enforceable.
It's
Again,
not
it's
enforceable?
something that somebody put in a lease. Like I say, Pauline do cartwheels. You can write it, but it's where do you enforce that? It's not enforceable. You can't contract outside of the act.
So all the clauses we put in are basically useless.
Garbage.
Unless it's in the act.
I'm sorry, but can you cut the tape?
Why don't you do our Schedule A?
Can you cut? No,
But I
sorry.
said that.
Why do we always schedule A?
Okay,
Why do we spend 30 minutes and not schedule A?
okay.
But I said that before, if it's not enforceable, you could put like all these agents put in all this stuff, you verify measurements, well, same with RICO, it's not enforceable, you put whatever you want in,
Yeah,
if it doesn't comply, it's not enforceable.
and that's exactly right. So they'll send me your Form 400, offer to lease, and that damn schedule with it. And I'll say, okay. And they'll say, well, I'll give it to the tenant anyway. Well, honestly, it serves no purpose. It's not enforceable,
You
okay?
just signed it to get the landlord to accept you.
Yeah, and
I actually am gonna disagree. I think there is a purpose. The purpose is that I'm playing devil's advocate because I'm very proud of my schedule.
Good.
and I'll probably delete half of it.
But you can, but
Oh, you would?
I think when we talk about the purpose, I think the purpose is for the tenant to have an understanding of what the landlord's expectations are. It's simply that. No, but there isn't enough information there to sort of have that discussion because there's
So
no.
the landlord said, Pauline, in that 40-page schedule, if there was a clause in there that said, Pauline, you're not allowed to cook after 9 o'clock.
Yeah.
So
Well,
what? It's
obviously.
not enforceable.
Yeah.
That's what I'm saying. So why is it there? So this with the 13 page, oh, we only got a portion of it.
Yeah, I deleted it.
He deleted it. Oh,
I
well
didn't
then.
print the other one.
Okay then. So you can have a look at that later. But there's like what, 7 pages or 13
Yeah,
pages
it
of
is.
that general
The
information?
appendix.
Yeah, so that tells everybody what your rights and obligations are. That schedule, honestly, when landlords or realtors send it to me and say, because I also do the residential lease. Okay, so if you were to say to me, Pauline, here's my offer to lease, I found a tenant, here's my, other attachment with it, I'll prepare the lease for $100. So I send you this back with a 1 page, probably 4 points, additional terms. Additional terms should be something like, who's responsible for the snow removal?
Oh, I have a little question about that.
Okay, go
Let
ahead.
her finish.
Yeah.
What are the other ones? What are the other ones?
You don't want the tenant to have a water bed or any water furniture, okay?
Mm.
Oh, okay.
Who's responsible for, God, what else do I write on there? The items that belong to the landlord, washer, dryer, fridge, stove, and so forth.
You have to put that in.
Well, I put it in because I had,
I mean, we have it in our schedule, but I'm thinking.
yeah, of course you do.
Of course.
I had,
They all belong to
But the schedule's
That'll
not
be-
enforceable, that's what she's
I
That
had
will
a
be in good
tenant
working order, yeah.
that left with the landlord's
I
appliances.
heard that.
Yeah,
Oh,
so,
shit.
yeah,
Yeah, I
so-
heard that.
yeah, and window coverings or stuff like that,
Yeah.
whatever, so, yeah, but I usually only have like 4 or 5 points, and then the guarantor, bet if you have a guarantor. But realtors will call me back and say, no, Pauline, the landlord's insisting that you put in all these. I can't, why, what is it for? It's not,
It's for the part of a discussion. I think it's part of that discussion to have so that there's an understanding of expectations between the landlord and the tenant.
Okay,
Peace
so-
of mind.
We
Is that a
know.
nice
Which
word,
doesn't mean
expectation?
anything, you
It
get-
You're
doesn't mean
smoothing over
anything
people.
because-
Okay, so
Peace of mind.
another one will say no smoking, no pets. No
Yeah.
pets, no smoking.
Yeah.
Again, that's not enforceable. It's not, it's
Yeah.
void under the
How
act.
about if the landlord lives and they have allergies, medical conditions?
Okay, so that's
That's
what I was
different.
saying to you earlier.
That's different.
You can write where it says no smoking, you can write because. As long as you give a reason, the landlord and tenant board believe that if there's grounds related to, not because they're smoking, or not because they have.
What about if the building is free?
That's different.
different.
They're required to
Okay, but
comply
you
with
see,
the
I
condo.
have a problem with the statement that it's not enforceable. Why don't we simply, like, I mean, this is, there used to be, as I say, a long time ago, the real estate deal was like a shaking a hand.
Oh,
yes?
sure,
This
yeah.
is an agreement between you and me. You tell me that you told me that you're not gonna smoke, whatever, you signed that. Only because this, I cannot enforce that, you said that there's no value of that, yes?
Okay, so you're all gonna hate me when I make
completely
this
wrong
statement.
approach.
Yes, I am a smoker, and yes, I had a cat, and yes, I rent. So, I went,
So you're gonna hide that, yes? Like,
I didn't hide anything. I went to the landlord, or like to the rental property that I was renting, and he looked at me and he handed me this lease to say, no smoking, no pets, yada yada. Signed it, went to the truck, started unpacking the furniture, came in, sat down, had a cigarette, and let my cat in. Not a thing he could do. Nothing. Nothing.
But then you're starting off on a conflict foot, so to speak.
Why? Why?
Because there'll be,
It's not enforceable. He can't say to me, now, had he said to me, Pauline, the people, they're shared, this is a multi-unit place, the people upstairs are on oxygen, or they have children, or they have allergies, fine. If you have a reason, grounds related to, not just because, it's not happening.
Could the grounds related to be you're turning my freshly paint turn yellow?
No.
No.
So I see.
Now,
see
I had
both
one
ways.
landlord, I'm not kidding you, in the 17 years I was there was one landlord that served the tenant with an N5, because the tenant smoked in the unit, and for that reason, when the tenant moved out, he had to take down everything. He couldn't just paint, he had to take all the drywall out, take the floor out, he got an eviction. Cause the tenants did damage, so he said, as a result of your smoking, you damaged my property.
Like a chainsaw.
So I see it both ways, and I know there's the problem in condos just for homeowners by themselves. Do you smoke? Can you not smoke? So I see both ways. For a tenant, you're paying your rent, it's your home, you should be allowed to smoke in your home if you want to. However, you don't own it, you're renting, so you shouldn't be allowed to just, yes, I agree, to trick the landlord to get in and then do whatever you want. I think if you sign that on the agreement of purchase or anything, you sign, yes, I'm not gonna smoke, and then you go in and smoke, whoever is breaking whatever they've signed should be responsible.
But they're asking you to sign something that's not enforceable.
Yeah, it's
But
not
it's
a law.
like
It's
it's
void
void.
under the act.
It
But it
should
isn't.
be, it should be.
It is.
It's not.
The law says we can.
Okay, so for the snow removal,
yeah,
you were
so-
gonna ask
Oh,
something,
yeah,
you wanna ask your question, cause I
snow
have a.
removal. This was specific, I thought of it last night. So
Oh, God.
I know that, landlords are responsible for snow removal.
Only if it's not stated under additional terms. So,
Oh, really?
what the act states is a landlord's required to maintain his property and keep it fit for habitation. So that would include snow removal. Unless, on your lease, under additional terms, you indicated that the tenant would be responsible for snow removal.
So if I put in the offer, tenants is gonna remove snow 24 hours after the snowfall, it's enforceable
Yes.
Not in the agreement to lease, in this.
in additional terms. Okay then, my,
No,
I
but
said,
it's, you
okay,
can
I-
attach it.
You can do additional
So
terms.
what we did, so what we did is, we had a rent X amount, and we gave a rent discount in order for them to do that, and if they stop doing that, then they lose the rent discount, is that?
That's challenging, you'll have to go through the board for that. So if the tenant, let's just say, no, really, let's just say,
But
for
is that
example.
still worth a shot?
Well, sure, you
Yeah,
can
you-
try it, but there's nothing illegal with doing that, but just a minute. If my rent is 2,500,
Yep.
and your agreement says that if I do the snow removal,
Yep.
my rent's now 2,300.
Yes.
You have to determine what would the true rent be, and there's a formula for that. Cause if you give a discount,
Yep.
and you give it where the discount totals more than 1 month's rent, that now becomes their true rent. The 2,300, not the 25. So when you go to increase the rent, you can only increase it on the 25. Or
No,
23,
23.
23. So you have to be cautious when doing any discounts.
Oh, that's good to know.
And why is it that in all, pretty much all our agreements when renting houses, the tenant ends up always assuming the
Landlord.
the landlord responsibilities, like there's no removal,
Yeah,
moving
well,
the-
because the act states, if you look under the maintenance portion, a landlord, or if you had have had that for the rest of this form. I'm
saving the planet by not renting so much.
Looks like. No, the landlord's responsible to maintain his property, keep it fit for habitation. Should the landlord not do that, the tenant can file a T6 application. However, you can write under additional terms that the tenant is responsible for snow removal, cutting grass, not to cut any shrubbery without the landlord's
Could you do no
consent.
smoking under additional terms?
Again,
Well, it's on the
Because-
lease, it
Yes,
says
it's
no
here.
smoking.
That's why I was like, how is it not enforceable if they're signing for it there?
Okay,
Well,
but
Listen.
it's giving you an opportunity to put a reason why there's no smoking. Condo court, you check off, it's a condo. Smoking, no smoking. Tenant needs to comply with the condo court, no smoking rules.
In a house, we would say allergies, for instance, something. you have to
Absolutely,
spell.
allergies or.
But you have to be in there,
Optional.
somebody else has to be in there and have the allergy.
Yeah, so it
Yeah,
has to
of
be
course.
grounds
No,
related to, not just no smoking.
So how would you put the additional term for the landscaping and the snow removal?
I would, under additional terms, I would put the tenant is responsible for removing snow and ice from the property. Tenant is responsible for like cutting grass and not removing any shrubbery without the landlord's consent, something like that.
And that should be the onus on the landlord or the tenant then?
Yeah, if the tenant signs that and they know that they're responsible for the shoveling,
Yep.
then yes, the tenant has to shovel.
Okay.
Same with the
And there's no
garbage.
coming back to that, right? Like we
Same.
cannot get, sorry about that, they cannot come back and say it's the land, because when you read the landlord and tenant board, it states or it looks like it's all of the responsibility of the landlord.
Well, it is unless it's been determined otherwise. Yeah, sorry.
Same with the garbage.
Yes, same with the garbage, yeah.
So like for instance, because I've seen this sixplexes, for instance, or fourplex, that one of the tenant is responsible for whatever maintenance or even cleaning the staircase.
Sure, they've made an agreement.
So then his real like so-called true rent will be whatever is minus that the
Well, if he's,
whatever his service is. Yes?
yeah, if he's working as a superintendent / property manager, whatever he's doing, the landlord and him have some terms as to what his rent is and what his pay, his
Yeah.
hired help is. So they probably already separated that.
Then my next question is, if you do a short-term rental, 6
I
months.
don't know what that is because,
6 month short-term rental.
no, there's
which-
no such thing because the act says, cause a lease expires doesn't mean the tenancy is terminated. You automatically go month to month.
No, new tenant, brand new
Yeah, so
tenant,
brand new tenant, you give them a 6-month rental, what happens, after the
short-term
6
rental,
months?
furnished short-term rental.
Yes, and after the 6 months, they automatically go month to month.
Correct. Then it falls under the landlord and tenant board?
They automatically fall
It
under that.
already did day one.
Yeah,
But if it was just a month to month from day one, same thing.
same thing,
Still
fall under the act. Any sort of landlord-tenant relationship, you're
Yeah,
talking
how
Airbnb.
high is
So then what
Yeah.
happens when they come in off an Airbnb, they do
Yeah,
a
that's what I was
45-month
gonna ask.
rental, they do a 45-day rental?
I think it goes to the Landlord Tenant Board Act, cause I was just reading an article in the Toronto Star, and it just automatically goes to that, and yeah, because I think the owner was trying to get rid of a client that, a tenant.
I
that
had
it
one
for
like
6
that.
months, they had a long,
Yeah. I had a landlord like that, I'm not kidding. Okay, so the act says, I'm a tenant, I advertise on Airbnb that I'm gonna I have a rent, or I'm gonna rent it out. I cannot make more collecting Airbnb than my rent, right? If my landlord thinks as a result of me doing that, I'm interfering with his rights and reasonable enjoyment of his unit, maybe too many visitors, parking, whatever the case may be, music, whatever, he can serve me with an N5. Stop doing that, okay? Or, like you say, in a condo court complaint to say, okay, your tenant up in unit 107 is operating an Airbnb. Here's the site. He went to the board with all, and I'm not kidding, all the bookings, and he tried to evict. He didn't get an eviction.
Oh my
What?
gosh.
And on what basis did they
Yeah.
not allow it? Did they?
I'm gonna have to look it up on the decisions, because all I know is he called me and he said I wasn't successful, but I didn't see the final decision.
So now give us some, sorry, go ahead.
Sorry, when you mentioned the website, you mentioned the decisions, so.
Yes,
The 2 and 4, like, so all decisions?
not all decisions, but, and the ones that are on there are what they call redacted, so they take out the names and just
Yeah,
put an
that's
initial,
fine.
right? So you can go in, on the ledger there on that side, hit decisions,
Yeah.
and then in the middle of this form, it'll come up and say Canelli, Candii, or whatever it is. I can't ever pronounce it right. And key in search words. So, search word would be Airbnb. And then it'll come up with all some of the decisions that they chose to redact. And you can read and make
Now in
comparisons.
the city, you can only do Airbnb of like rooms, but not the full property,
Not full
right? So
property.
that wouldn't go into the landlord and tenant
Right,
work, 'cause
and-
you're only renting
Right,
a room.
exactly, yeah. And that's another good point, if a tenant's required to share a kitchen or a bathroom with the landlord, they're not covered under the act. They're exempt.
What about with students?
Yeah, that's a big issue, because a landlord will, let's say, have, a basement, and he'll have 3 rooms with each individual student.
Each one.
And those students will share the common area, kitchen and bathroom. They're covered under the act. The only thing I would suggest is you gotta label those rooms. Room 1, room 2, room 3, you have 3 separate leases, because if that person doesn't pay, you don't want the sheriff to evict all the people, you want him just to evict that one. But the sheriff has to know who he's evicting, okay, so you have to identify the rooms. Where else were we going with that?
Not
What if
covered under
they-
the act.
What if they?
Oh, if you share a kitchen or a bathroom.
Yeah.
Yeah, if you, pardon me, I'm so sorry. If you share a kitchen or a bathroom with the landlord or a member of the landlord's family, you're not covered under the law at all. So if the landlord wants you out, calls the police and says, I got a party here trespassing, they're not covered under the act. They're exempt. They share a kitchen and bathroom.
What if you Airbnb your basement and it's got a kitchen, a bathroom, and a 1 bedroom?
Yeah, the landlord and tenant board, when I was there, well, Airbnb, I mean, I'm going back to 2016 when I left. Airbnb wasn't such a big thing that the board had to deal with, so I'm not really familiar. I mean, you can serve an N5 to your tenant if you think they're doing anything that is interfering with your lawful right, privilege as a landlord, or your best interest.
It would be like more like, are you sharing the bathroom and the kitchen with the Airbnb people?
Mm-hmm.
And if there was a separate unit contained by its own, it'd probably be under the act, no?
And somebody here had asked me before about a family member, that, does they fall under the landlord-tenant act? If he's renting, say your son's renting.
Yes, if they're paying rent, then yes, because, and that's exactly, I had one before where the owner let his granddaughter or whatever stay, and now it's been really problematic. That granddaughter's never paid a dime in rent, so she's not even a tenant.
If you have a landlord and a tenant on a lease, and the tenant has an adult child, the tenant now moves out.
And
So the
other
lease
tax.
is still with the adult that moved out, the adult child is now there. How, so they're not on the lease.
They're not on
Who's
the lease, but
paying?
That's
yeah,
people
if he-
assigned
if
to
he's
somebody.
paying,
He's now paying the
Yes.
parent who moved out, who's
Yes.
paying the rent.
yes, so now he has a right to occupy, he's a tenant.
But can the,
Is that
The
considered a tenant or
landlord-
sub?
No, so,
sorry, the landlord of the building, can they throw out the adult child because the original person on the lease is no longer there?
Okay, but it almost sounds then that they've assigned the unit to the
But they haven't
son.
officially done anything, they're just, the adult, the parent moved out,
Sounds
the
like a
adult
sublease.
So
child's
then the
still there.
landlord, on the A2, it says, when did you find out that the unit has been assigned? Like, when did you find out that the other, one person moved out and the son is there? So
The
you have,
landlord has never found out that the person's moved out.
The son moved in to help the child.
The son was already there.
No, for example, yeah, so for example, the
mom
son
left.
moved in to come help the kid,
No.
right?
No.
No, it's not.
The son and the mom live there. The mom left and has a
Son.
different place
And the
where
son
she
assumed
lives.
the
The
property.
son has stayed at the apartment because it's very cheap rent.
okay, so my
paying the
question to you
rent?
is, how do we know this? And when did they find out about this?
The landlord doesn't.
The
know, she
landlord
said.
doesn't know, that's my question.
But
What
let's
if,
say the
how do we
landlord did find
protect
out.
the son who's now there? Can his mom add him to the lease?
No, because he's already there. He's
Right,
already
but
in there.
he's been there since he was a baby.
Yeah, I understand
So as
totally.
he's an adult, can he not be added to the lease once he becomes an adult?
No.
Is that lease still like? is
They
it
have to
monthly?
terminate one tenancy and
No, it's,
reestablish another.
she signed a yearly lease. So I guess that my question is, does he have any?
What protection does he have to stay there?
Right, like if the landlord of the apartment building
Just
finds.
keep proof that he's paid rent.
But he's not paying.
And the
rent.
mother has to
He's
be
paying rent to the
renewing
mom.
every year.
Yeah, but
Okay.
why is some other paying, okay, so,
Okay, so she.
in order,
left.
I get what you, I know exactly what you're saying, but in
Yeah.
order to protect himself, he needs to say to his mom, you need to give me the rent and it has to come from my account. I have to show proof that I'm paying the rent in order to be recognized as a tenant.
So right now he doesn't have any right.
Right,
I don't think so.
I see.
so he
So-
could be thrown out.
He's not
Yeah,
existent
so
really.
if that happens and the landlord doesn't like it, where the money's coming from, has he any grounds to do anything to that, to the son?
Well, he could file an application to say, the landlord believed, cause the mother moved out, that's the key.
Yes.
When the mother moved out, everybody should have moved out. So if he's they're assigning the unit so that the son can stay there and she's continuing paying the rent and whatever. The landlord could file an application to say, I believe that the tenant moved out and the tenant assigned the unit to an unauthorized occupant. I'm asking the board to terminate the original tenancy and evict him.
There's absolutely nothing really he can do right now.
Well, he's
Until
already
he
in.
proves that he's paying from his account.
Well, that's why I say, if he proves that he's paying from his account, if he can show the board to say, no, I've established tenancy, because,
Yeah, he's paying his mom.
well, then I don't know.
I wouldn't get
Go
into
with
open
that.
that can of worms because the rent is cheap.
Yeah,
My
and
son, my son is one of the
I
tenants.
know.
Yeah.
So I was just trying to figure out how we're gonna.
bottom line is,
Yeah,
at the board, there's never been two cases that are ever the same.
so she cannot add another adult to the lease.
No, the lease expired, you said they're month to
No,
month
there's
now.
no lease.
Yeah, there's no lease.
She signs the lease every year.
Oh, she signs the lease
Yeah.
every year?
There's an existing lease, so can she just add her son to the lease?
Well, if the
Give
landlord,
to the
what they
landlord.
normally do is they terminate the original tenancy and reestablish a new one.
And then they can increase.
But then, like you
Exactly.
just said, if it's cheap rent, do you really wanna
It
go
is
there?
cheap rent.
It's a very, okay.
I would not poke that bear.
Once we were selling, there were 3-unit triplex in my park, yes, and the buyer, he wanted to have those tenants because it was a business, yes? So is it prudent that before the offer is accepted or after, there will be a question also when to do it, to ask the tenants whether to declare themselves they're gonna stay, for instance, right? That they will declare, yes, we're gonna stay, and is it a forcible once, and then is it in a specific form for that or not?
No, cause the tenant stays until they've been told to vacate. So they don't have to say to you, yes, okay, you're taking over the building now, yes, I will stay. They're automatically staying until.
I'm
the board-
talking about the month to month, of course, because
Yeah.
so someone has a 1-year lease, it's
Sure.
a declaration that he will stay
Yeah,
there.
the tenant doesn't have to explain whether they're leaving or they're staying. The tenant automatically stays until they've been told to vacate.
Ah, okay.
I have a question. I'm not sure if you're gonna be able to answer it because it is on the new vacant home tax. But if a landlord rents out the place 1-year term and the tenant is gone for more than 6 months out of the year, which would mean that the homeowner would then have to pay the vacant, or I don't know if they would have to pay it because they have an agreement for a 1-year term. So how would that kind of work? Like if
Yeah, I'll be really honest, I'm not familiar with that tax or law, or that law.
yeah.
Probably because it's so new.
Well, yeah, I'm gonna thank you.
Oh, sorry.
I'm gonna call it a day.
I'm getting booted out.
I'm putting Pauline on the door, honey.
You're a sweetheart.
cards?
I
Does she have
don't,
cards?
but I will send my email address
Okay.
and, as contact information.
Thank you, thank you, Pauline, it's been a blast.
Thank you.
Thank you, everybody.
Proud.
And I'd also like to welcome Samantha to the team. Stand up, Sam. Hello. Everybody meet Maritzu. You met Maritzu? Everybody's met Maritzu, and anybody
And
else?
we're all good to go.
Good. Party on, guys. Thank you.
You're more than
Thank you
welcome.
for the applause.